Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
All right. Good morning, everyone. Welcome to today's show here on Tuesday. It is Tuesday at 10 a.m. at a regularly scheduled time. Today in the studio, we have back my co-host, Bill Bernard. Welcome back, Bill.
Back, bright-eyed and bushy-tailed. Thank you, Rick. Glad to be here, back in the Southern California studios. Hope our viewers and listeners have had a prosperous week. And we have what I think should be an interesting show on tap today, and I hopefully it'll be a practical show. People will be able to use this information, and both in a business and in a personal setting.
Excellent. So today, if you're a very first-time viewer or listener here to the Bottled Business Sense show, we're here every Tuesdays at 10 a.m. Pacific time. And Bill and I host a casual talk show, which we are the hosts of, that deal with marketing and business perspectives for small businesses and how we can help provide information that may enhance or help your what you're doing in business. So I'm really excited about today's episode today here with Bill. We are going to continue on legal aspects of business, and specifically we're going to talk about the powers of attorney. So how we have that broken out today for Bill is that we're going to talk about the basic principles of the powers of attorney, the types of different powers of attorney, the power itself, and Bill will elaborate a little bit more on that, as well as the process, and then of course the duty. So without further ado, let's get into the topic here. It's going to be a very valuable one. So
yes, I think it will. It's going to be entitled "The Scoop and Scope of Powers of Attorney." And by the way, I've made my own outline of this that I utilized from an article that I wrote personally on my website called BottledBusinessSense.com. As you know, Bottled Business Sense Show is a takeoff from our newsletter site. So BottledBusinessSense.com, under the estate planning section, will have a really good in-depth review of the scoop and scope of powers of attorney, what we're going to speak a little about here today. So if you'd like your own little article or reference material on that, feel free to go to BottledBusinessSense.com. Powers of attorney can be used, as Rick said, our show being about business and legal aspects of business, can be used in both a business setting for a business owner and, of course, in an estate planning setting. So I thought what we'd first talk about is the basic principles of a power of attorney, and I want to say right up front the obvious. Number one, it's a legal document, okay, that appoints another to act in your place. Okay, so that person can act in your place when you are unable to, and that's the key word, unable. Unable, depending on how you want to put a meaning on it, can mean different things. Let's face it, you're unable because you can't do something, or you're unable because you choose not to do something.
We talked about something similar to this, although this is very different. Kind of like in a trust, except you're giving control to somebody else to do what you want them to do.
Right, and you can do that under a number of different scenarios, and we're going to talk about those. The second point I wanted to make is, remember that the maker of the power of attorney, the one choosing to make the power of attorney, is the principal, and he's appointing the attorney in fact to act in his place. The attorney, in fact, is the agent. So you have the principal, who's the maker of the document. You have the agent, who is the attorney, in fact, who operates under the power of attorney. So what does that mean? That means under principal and agency law, which we're going to talk about again in another show, a future show. Under normal circumstances, the principal is responsible for the acts of the agent because the agent is given permission to act on the principal's behalf. Okay. The third point I wanted to say is that all powers of attorney terminate upon the death of the principal or the maker. There is no ifs, ands, or buts. They terminate. Now we're going to talk about some distinctions between different types of powers of attorney and when they may terminate, but regardless, all of them definitely terminate upon death of the maker.
Now, just to clarify, when you assign somebody the power of attorney, it doesn't necessarily mean an attorney, does it?
No.
Yeah.
No, I could make you my power of attorney.
Okay. Right.
You're the attorney in fact. Okay? Meaning that factually you're acting as my attorney would act under normal circumstances. But you're not an attorney and you don't have to be a licensed attorney.
Right. I wanted to clarify that for the audience because there's a lot of attorney verbiage that's going on.
No, that's good. We need to make it clear for the audience. We try to break it down so... look, we're here, folks. We don't want to insult anybody's intelligence, but by the same token, there are people that need to know the basics that don't know them, and so we try to cover the full gamut here, and hopefully do so in a respectful way. The fourth principle I want to talk about is that a principal or the maker may revoke the power of attorney at any time as long as he or she is competent. So if you make a power of attorney and you want to revoke it, you can, with one exception. You either become incompetent, and then there's going to have to be some action to make sure that this power of attorney is broken if someone feels it should be, or you have a power of attorney that has a limited time period involved. So in other words, you have a power of attorney that says in it, you are my power of attorney until June 12th, 2020.
Okay.
When that comes along, that power of attorney is terminated upon that date.
So you can timestamp it and put any conditions, basically any conditions, I guess, as the creator, right?
Right.
On that. So
well, some within reason, yeah.
Right.
But remember that the maker or the principal is going to create the conditions under which he wants the power of attorney to operate. As long as it's not in contravention of law or against public policy, generally you're okay.
Okay. So then that would lead to the next question then. What types of power of attorneys are there?
Well, we're going to get to that, but I have one more point.
Okay.
Rick's jumping the gun on me here, folks.
Sorry.
So remember, the first area we're talking about are the 5 basic principles. And by the way, I don't want to confuse anybody. The principles we're talking about are the ideas, right? Principles. The maker of the power of attorney is also a principal, which is Principal, right? Okay, so let's keep that. I don't want to confuse anybody. So we talked about the fact that the power of attorney is a legal document, the fact that the maker of the power of attorney is a principal, and the agent is the attorney in fact. Number 3, all powers of attorney terminate upon death of the principal. Number 4, the principal may revoke the power of attorney at any time as long as he or she is competent. Number 5 is that a successor agent may be named in the power of attorney should the first one be unable to act due to death or incapacity. So just like in a trust, you can name a successor to act in the first attorney in fact's place if those circumstances come about. Okay, now to Rick's question, we're going to talk about area number 2, which are the types of powers of attorney, and they can be either general, durable, or limited. General, durable, or limited. Let's talk about a general power of attorney. This essentially grants broad powers to the attorney in fact to act in regard to the principal's assets and property while the principal is alive and not incapacitated. So a general power of attorney is going to allow you to act on the maker's behalf or the principal's behalf as long as he says you can and as long as he's competent. If he becomes incompetent, the general power of attorney ceases to have power.
So, just again, just clarify for our audience, when you say incapacitated, what it's probably obvious, but
Well, it usually, generally, as much as in a trust package, when you have healthcare directives and powers of attorney for health, it's usually specified that 1 or 2 doctors will have to certify you as mentally incompetent, where you cannot serve on your own behalf, and generally that's the standard. That can still be challenged by other people, but nevertheless, you're going to have somebody pronounce you as being incapacitated, or if you're committed to an institution or something like that, or if you're physically incapacitated and unable to act physically and do the things that you need to do to make different parts of your business or personal life move forward, you could be considered, potentially be considered incapacitated. But generally, it's referred to in the mental sense.
okay.
And you're going to have somebody, generally pronounce you as being incapacitated.
Okay, so how does someone prepare around that?
Well, when you say prepare around it, you
well,
mean-
I guess in the eventuality that could happen, how would they? How would they?
how would they have a power of attorney last, even if the person's incompetent?
Yes, yeah.
Sure. Well, that's a good point, Rick. That brings us to the durable power of attorney, and that is a takeoff of the general power of attorney, and that allows you to act even when the person is incapacitated. Okay? So general gives you broad powers in regard to the principal's assets. The attorney, in fact, can act with regard to the principal's assets. Durable, same thing, only durable you can act even when the principal's incapacitated. General, you cannot. Okay? And then the third type would be a limited power of attorney, which restricts the attorney, in fact, or the agent's ability to do certain things over a specified period of time or a specific accomplishment. In other words, you could have a healthcare power of attorney, that this power of attorney only comes into effect when the person has a health issue. And this person has specified that when I have a health issue, you're going to be my attorney. In fact, more particularly, it's limited to when you become incapacitated. So you have a limited power of attorney, which is the opposite of a general power of attorney, which says it stops when you're incapacitated. A limited will say it begins when you're incapacitated.
Ah,
Okay?
Yeah, that makes total sense.
Or if you're going to buy real estate, is another good example. Let's say you're out of state and you want somebody to purchase real estate for you, or you want somebody to enter into some legal transaction for you, and you're unable to do so. You would make a specific power of attorney or a limited power of attorney that says, for this deal, this guy can be my attorney in fact. After this deal's over with, the attorney and the power of attorney extinguishes itself, or he's my attorney in fact for a series of deals ending on whatever date.
Okay. Well, that makes that. Yeah, absolutely. That one makes total sense. Just for my curiosity, is there an example that you could share with the viewers here on why they would do a general versus a durable power of attorney? I mean, is there an advantage to one or the other?
Well, because sometimes people don't anticipate that they're going to become incapacitated. Here's a good reason. The durable power of attorney, which allows you to act even when you're incapacitated, is usually something that you could include in a trust package. So I'm going to have my power of attorney for assets, or my durable power of attorney here, and it's going to say that you can act on my behalf when I'm incapacitated. Okay? And you can even call it more specifically a specific power of attorney, because it acts only upon incapacitation. So here's what I'm going to do. I want a specific power of attorney inserted in my trust package that says it's specific and limited only to when I'm incapacitated. However, you're my business person, and I want you to have a durable power of attorney that allows you to act even when I'm not incapacitated and run my business or certain business aspects of my life, and continue on to even if I become incapacitated. Right? Now, I want a general power of attorney because I have somebody else who's going to act for me that I care about more, who is more concerned, who has more importance in my life. So I'm going to have that person be my limited power of attorney upon incapacity. You are going to be my general power of attorney only to handle my business assets or my business transactions over a certain period of time. Okay? I'm not interested in having you involved if I should become incapacitated, because while you're a savvy guy and you make smart decisions, I'm not going to trust you with my money when I'm incapacitated and I can't watch over you. Okay?
Right.
You just simply, to put it simply for the viewers and listeners, you have different circumstances where people will choose different powers of attorney. It could be a limited period of time. It could be incapacity issues. It could be just someone who you want is your business manager and you want to just handle your transactions and you don't want to be involved. All of that's going to go into the mix to determine what you're going to pick as your general power of attorney.
Okay, that makes total sense. So we talked about the 5 principles. Bill's explained the different types of powers of attorney, and now let's why don't we lead in and talk a little bit about the power itself?
The power itself, yes. What is it that you can do when you have this power of attorney? Well, you're able to make business decisions. And you're able to sign documents and execute documents on behalf of the principal. And you're able to, just as importantly, take necessary actions to implement whatever decisions you make and whatever documents you execute. A good example, you were asking before about why would certain people pick maybe a general power of attorney versus a durable? I think you asked.
Yeah.
A good example would be military deployment. Guy's going overseas, right? And he has no interest in having you be the power of attorney for the duration, meaning even when he's incapacitated. He wants you to handle his business decisions while he's gone. So he gives you a general power of attorney, okay? That he can revoke at any time, and he will revoke it once he returns home. By the same token, he can make it a durable power of attorney. He can say, while I'm gone, I want you to act as my power of attorney, and should I become incapacitated or unable, remember that key word, unable to act because of some physical or mental injury I suffer in my deployment, you are now going to have a durable power of attorney. You can act when I'm when I have capacity and when I'm incapacitated. And a doctor, again, would be involved in pronouncing someone as incapacitated. The beauty is, let's say a guy gets injured, and I don't mean to sound that way, but the interesting part of this is a guy gets seriously injured, but he's not mentally incapacitated in overseas, and he can't attend to his business. Well, he's not incapacitated mentally, he may be physically. He can still have a person in the States operate as his general power of attorney and just not revoke that general power of attorney until he comes home. And even if he comes home and he's an invalid, he may choose not to revoke it at that time. Again, incapacity generally referring to mental incapacity. Now, if he wants to cover that basis as well, he may get back home under the general power of attorney and turn it into a durable one, where he says, okay, now you can act on my behalf whether I have capacity or incapacity.
Okay. So, and this power can apply to your personal things as well as your business, right?
It can apply to generally anything you want it to apply to. There's 2 general basic major categories. Assets, and assets, of course, can be real property and personal property, and then, of course, healthcare. So you can cover the gamut generally under those 2 situations. If you're going to make a specific or limited power of attorney, the third one we spoke about earlier, which is limited to a specific period of time or for a specific transaction, then you can put in there what the power of attorney is meant to handle, what specific transaction it's meant to encompass.
Okay.
Now, remember that without a power of attorney, a spouse, a parent, or other interested party must petition the court to be appointed as a guardian. So, if you don't have a power of attorney and you become incapacitated and it doesn't cover incapacity, well, then that person can't act as your power of attorney, right? In other words, he's going to have a power of attorney that allows you to act when he becomes incapacitated.
So the power of attorney already has to be in place?
Well, the power of attorney, if it's durable, covers acting on your behalf when you're incapacitated.
Right.
If somebody wants to challenge that, they have to go to court.
Oh,
If they want to challenge the legality of that. However, without a power of attorney at all, zero, zip, none, you become incapacitated and somebody wants to handle your affairs, they have to go to court and start a conservatorship. And it has to be your conservator. That's a lengthy, no, I shouldn't say lengthy. Generally speaking, it could be lengthy. And much more convoluted than a simple power of attorney, and the biggest key is much more expensive.
So that wouldn't apply if you had a spouse. She wouldn't be the beneficiary that would handle all that stuff?
Without a power of attorney, if the spouse isn't named in the business or the spouse's name isn't on the assets or she doesn't own part of it, then she's going to have some difficulty. Shouldn't have much difficulty being appointed a conservator. But remember, there could be property that doesn't belong to her and that she's going to now have to control on behalf of the husband.
Oh, sure. Okay.
The other issue is a lot of times there are fights that erupt between people who claim they're not incapacitated, but people try to get a conservatorship over them because there's no power of attorney, and the person trying to get the conservatorship is saying you are incapacitated. And many times that can happen between family members, and that gets messy.
Yeah.
I have one going on right now, as a matter of fact, between a mother and a daughter.
I can imagine.
It's
not pretty, all right?
You got to think about, is it worth destroying your relationship? On the other hand, some people feel it's absolutely critical to do it because they fear for the well-being of the person who they claim is incapacitated. So in any event, Rick, that kind of gives you a general idea of some of the powers that have to be implemented and what happens if you don't have a power of attorney in order to take care of someone's assets, and it could become problematic.
Yeah. Well, folks, if you know somebody or you are in a situation where you need something like this to be addressed, Bill is a great guy to come to because he takes the very complex legal things that we as lay people tend not to understand and makes it very simple to understand, so it's easy to make the right decision. And so if you have any questions, give Bill a call. Bill, tell us how to get a hold of you, and then also, what other things do you do in your business? What other types of things do you cover?
Well, as we've said from the outset of our shows, my platform is built on three principles, or three stages, you might say. It involves asset protection, which involves making sure you have the right insurance and making sure you have a business entity that you're operating under. It involves estate planning, which of course ties into the protection of the personal assets, and it of course, which by the way, both estate planning and asset protection intricately involve what we're talking about here today, powers of attorney. And then thirdly, employment law, because you need to make sure when that business is up and running properly and is protected, that it has the proper employment safeguards in place, from anything to the relevant posters that need to be posted for state and federal law, as well as an employee handbook, especially, of course, if you have employees. I can be contacted at wfblegalconsulting.com. And the email there is bill@wfblegalconsulting.com, and my phone numbers are 949 area code 413-6535, 413-6535, and 698-6222. That's 698-6222.
Okay. Here, as we get into the back half of the show here, we're going to continue on with Bill's topic of the scoop and scope of powers of attorney. We are on the subject of powers of attorney. We talked about the 5 different basic principles, the types of powers of attorney. We just talked about the power itself, what that means and what kind of control somebody can assign. Now, how does someone formalize the process?
Okay, we do have to have the process itself, and that is very, very, really straightforward, candidly. The attorney draws up the power of attorney. It typically has to be signed by the principal and needs to be witnessed. I would urge you to have maybe 2 witnesses witness the power of attorney. who know you and can attest to your capacity. And then it is acknowledged and signed by the witnesses and by you in front of a notary public. And usually they do not, in fact, always, unless there's a specific state law that requires it, you don't have to have powers of attorney recorded with the county recorder's office. Why is that important? Well, as we talked about when we have a trust package, which involves powers of attorney for both assets and healthcare, we want a trust and its attendant powers of attorney because it's a privacy issue, right? Once you file something with the court, once you have a will and no trust, once you don't have a will and you go by way of intestate succession with regard to your estate, it all becomes a court matter, and that means it's public documents. It's public. Anybody can find out anything they want about your estate. Without having to file a power of attorney, of course, it remains private. We, of course, want to talk about what if you want to revoke, cancel, or end the power of attorney before it expires. If you have a power of attorney that is not supposed to expire before a certain date, and the principal wants to revoke it, he signs a revocation. The revocation is drawn up by the attorney, and the revocation is signed by the principal or the maker, and then the power of attorney is revoked. Likewise, if it can be revoked at any time, he's going to sign a revocation. That's going to be required. And of course, you want to try to give copies of these revocations, or this revocation. You want to give copies of these to the prospective business people that you're dealing with, like a bank, for example. Anybody where you have your assets being transacted by this attorney in fact. You want to give them a copy of the revocation. Why? Because without that revocation, without them knowing that the power of attorney has been revoked, the attorney in fact can still claim and still act on your behalf. And we have then what we term in the law as apparent authority. Apparent authority means that if you you claim you're acting on someone's behalf, and you give the impression that you have the ability to act on someone's behalf because this person previously was operating under a power of attorney, right? Well, then that third party, whoever you're transacting business with, may have the right to assume that you have the authority to do so.
So that begs the question then: when is it true? When is the revocation in effect? The moment they signed?
Legally, it's in effect at the time of the signature of the revocation. Okay. Mm-hmm. And I would also urge to have that witnessed and notarized. But you want to make sure to cover all your bases, just so there's no things that happen in between a lapse of time. You get that revocation signed and notarized, you immediately send it by email or by mail, or personally deliver it to anybody who has transacted business transactions or personal transactions on your behalf by your attorney in fact. Okay, so it's now, can something happen in between you actually sign a document and get it to all your people, or all your third parties? Well, sure, but that's far and few between. And my point is, you need to get it out to the people, the third parties that have been in business transactions involving your assets. So,
let me hypothetically say then, in because of unforeseeable circumstances, there's a lapse in time where the person that does the revocation isn't in contact with the person that they've given power of attorney to, and they're acting as what was the term? They were acting as
attorney in fact.
Attorney in fact, and they do something,
right?
And that leads to something not good.
That leads to something not good for you. Well, remember, the key is it reasonable? Is it reasonable for that third party to have believed that your attorney, in fact, had the ability to do the transaction that he did, claiming that it was done on your behalf? It just depends on the facts and circumstances. If you don't get this revocation to the third party for 6 months after you sign it and notarize it, it might be reasonable for him to assume that. It might be also reasonable for him to assume it if it happens the very next day, depending on the kind of transaction. Is this a transaction that the attorney, in fact, was asked to do for you as part of you making the power of attorney, or is it something that might be outside the scope of what that power of attorney was originally designed for? It's apparent authority is one of the most litigated aspects of the law that we encounter. People claim to do things for other people all the time, and then the courts are going to have to examine whether it's reasonable under the circumstances. So my basic thing is, before I do the revocation, I send out a letter to all of the people on behalf of my client that have to know that there's going to be a revocation. I say the revocation is going to take effect on such and such a date. Please be aware of this, and there are no more transactions should be conducted on behalf of the attorney in fact. I will send you a notarized copy of the revocation by such and such a date.
Yeah.
So they're on notice of it. Now, if they're on notice of it, and it's coming from me, and they act anyway, in conjunction with the attorney in fact, the question of reasonableness will come up.
Right. Well, that would seem to me should be standard practice when you're going through a revocation, but that doesn't always happen, right?
You would think, Rick. Right. I mean, a lot of what we normally believe are standard should be standard practices, and it's like I said in one of our other shows. Excuse me. Some people would rather buy a big screen TV than get a trust. So who can tell?
Good point.
But the last section I want to cover is the actual duty that someone has under a power of attorney. Remember that under a power of attorney, you are the agent of the principal or the maker of the power of attorney. This is very important because it creates what is called in the law a fiduciary duty of loyalty. It creates a special relationship of trust and confidence whereby you are promising to act on the behalf of the attorney and the maker and the principal of the document, the power of attorney. And the power of attorney is promising that he is giving you the authority to so act as his agent in fact or his attorney in fact. Remember, agent in fact, attorney in fact are the same person. That's the person that's acting on your behalf. The maker or the principal is the person who's creating the power of attorney. Okay? But let me make clear that not only is this the same fiduciary duty that a lawyer has with his client, but you are, as a practical matter, giving someone a power of attorney and taking a risk that you could, in fact, lose your assets. I mean, so there's always that chance.
Yeah, right.
But of course, the idea is you're not going to give it to just some guy, some willy-nilly, person off the street. You're going to give it to somebody you trust.
You should be choosing wisely, right?
That's exactly right. They couldn't emphasize that more.
Yeah.
Excuse me. Powers of attorney, by the way, don't usually contain provisions requiring the agent to give you a financial accounting of the affairs. That is something that you would have to require in the power of attorney, specifying in the power of attorney that every 2 months or every 3 months I want you to give me an accounting as to what's been going on, what money's been transacted, what business deals have been conducted. Typically, without that wouldn't be part of a power of attorney. And remember that the agent under a power of attorney cannot, we've referenced this at the top of the show, cannot make decisions on your behalf after death. All powers of attorney terminate upon death. What's that mean? That means, Rick, that a living trust is essential as part of the package. Because why? A trustee can act and is supposed to act on your behalf after death, right? So don't mistake a power of attorney, an attorney in fact, of a power of attorney. Don't mistake him for being a trustee. It can't happen. You can't have your power of attorney in place of a trust. Power of attorney is a lot less expensive document, so I don't want people to think, well, I can just get a power of attorney, and then after I die, he can do what he needs to do. I won't have to go to probate court.
Right. And folks, this is why you need to talk to somebody like Bill, because he's got you covered from both
stem
ends,
to stern. Right? We try. That's the business in a bottle, right?
That's right.
We try. We try to do that. And of course, I mentioned that you do not need to have powers of attorney recorded with the court. However, one circumstance requires that you do so.
No, what's that?
Well, the law requires that real estate transactions be in writing. So if your power of attorney is conducting a real estate transaction on your behalf, a real estate deal, that power of attorney should be recorded because it involves real estate. Okay, so that's one of the side issues that you might want to keep in mind when you go to get what would be called a limited power of attorney, because you want it for specific transactions.
Are there any other circumstances where they would need to be recorded?
Generally, no.
Yeah.
Generally, no. It would require no recordation unless it's going to involve real estate. There may be some more convoluted issues involving recordation that I don't want to get into for purposes of this show, but if somebody came to me with specific ideas or specific fact patterns, if you will, then I might be able to get into that, or maybe I should get into that with them. But again, we try to impart general knowledge to our listeners and our viewers to try to take our show, of course, Rick, and make it into a legal seminar would be a mistake on both our parts and would do a disservice to our listeners and viewers. So let's do a recap of the show. Not a full recap, but just a couple of small pointers that I think is important to remember as we close the show. Remember, you can always specify the ending date to a power of attorney. If you don't, it ends when you become disabled, unless it's durable. Then it carries on even when you're disabled and ends upon death. Pretty straightforward.
Yeah.
If it is durable, as we just mentioned, it does survive your disability, but it is not immortal. It dies when you die. And your agent, upon your death, loses power to make all the decisions for you. That's why when your power of attorney dies, along with your agent in fact doesn't die, but he dies from the standpoint that he has no more power, then what comes after the attorney in fact?
Living trust, right?
You got it. The trustee
Yeah.
takes over and does what needs to be done. And that brings us to the last point of the recap. Do not rely on a power of attorney as a substitute for a living trust. So with that, I hope this show has been helpful to all of you, and I think you might get a good general idea of how it covers the gambit of business and personal issues. It could cover health issues because you have a power of attorney who takes over when you are incapacitated and need health decisions made for you. That power of attorney, generally speaking, is a spouse. And then you have somebody who steps in if the spouse is incapacitated and so forth, and generally sons or daughters. So powers of attorney for assets, powers of attorney for health care are the two principal ones that we normally deal with, and they're well worth everyone's while to have in place.
Yeah. Well, this was an excellent show, Bill. I mean, as your co-host, I love how you paint a picture of the whole story that you've been talking about for the last several weeks, right? As we've been talking about legal topics for the show, and I have much clearer picture on how the power of attorney works in conjunction with the living trust and some of the other topics that you've talked about. And so, folks, if you have any questions or just want to drop Bill a line, his contact information is here at the bottom of the screen, and he'd be more than happy to take up a discussion with you to see how he can help.
Right. I would. And again, remember, some of these things can be obtained. This is information we provide to you to help you. And some of this information can be gotten at bottlebusinesssense.com in the newsletter area. And at bottlebusinesssenseshow.com, because you always have the opportunity to log in and listen to a show whenever you're at your leisure, right?
Yep, absolutely. Good point.
Okay.
Well, that wraps up today's show on the powers of attorney. And so come join us again next week at 10 a.m. Pacific time here at the bottlebusinesssenseshow.com or on Blog Talk Radio.
Good. When we hope you'll join us, and by that time we'll have the fly out of the studio. So take care, everybody. Have a great week, a prosperous week, and we'll see you next week.
All right. We'll see everyone next week.